All right, good afternoon, everyone. Welcome to the 200th District Court. This is Judge Jessica Mangrum. We're here this afternoon, Afo Holdings LLC versus M&B Aviation Holdings LLC et al. Counsel, go ahead and state your appearances for the record.
Your Honor, Jeff Johnson for the plaintiff, Afo Holdings LLC.
Your Honor, Jules Slim for M&V Aviation Holdings and Mr. Gira.
Okay. All right, Mr. Johnson, it's your application, so I will let you proceed first. Just a reminder to counsel, these are brief emergency hearings, and we have several others scheduled this afternoon, so the court is really not able to give an extensive amount of time for these are short hearings.
Understood, Your Honor, and thank you. I would take my lead from you, Your Honor. We have submitted all of the pleadings, the verified pleadings, and I'm happy to start from the top, but I'm also happy to address issues that stand out to you, whatever you would prefer.
I guess you can go ahead with a basic overview. I mean, I have read the application, the defendant's response, and then the plaintiff's reply. So while I'm familiar with what you have filed, you may want to just review kind of the pertinent history of this transaction and where things stand between the parties.
Yes, Your Honor, I'd be happy to do that. This is a dispute over the purchase of an aircraft, specifically a Cessna Citation. And on April 8th of this year, the plaintiff and defendant M&V entered into a contract for the purchase of that aircraft. And this was a bargain for contract. It wasn't a form contract. It wasn't anything like that. There were red lines that went back and forth, and the parties had things that were important to them that they insisted on, and they negotiated and finally ended up with the contract that they both signed, which you have, Your Honor, as Exhibit A to the second amended petition and application for TRO. Two of the bargained for exchanges that are really important here are, the first is that one of the contract has delivery conditions, meaning that if the purchaser accepted the aircraft after a pre-inspection, a pre-purchase inspection, then the seller had to deliver the aircraft to the purchaser, complying with certain delivery conditions. And the main delivery condition is that the aircraft would be delivered in an airworthy condition. And that's important here. That was specifically negotiated for and agreed to by the parties. Second one is perhaps even more important, and that's that parties here agreed that in the event of default by the seller, there were two appropriate remedies, and only two. The first was specific performance. The plaintiff could come here and could request specific performance from the court. That's the only remedy that, if the plaintiff wanted to move forward with the sale, that the plaintiff is authorized per the agreement to pursue. If the plaintiff didn't want to compel specific performance, then the plaintiff could walk away. And it was only those two things. There was no agreement that in the event of default, plaintiff could come to court and seek monetary damages. And the reason for that is this, Your Honor, because the contract was for the sale not just of any aircraft, not just of any Cessna Citation, but this Cessna Citation. And so it was important to the plaintiff, and the plaintiff attests to this in the pleadings, that this aircraft be the one that was purchased and not a replacement, not a substitute, not cover for this, not money damages. It was this. And so they negotiated specific performance. Under the contract, plaintiff wired $50,000 to the defendant. Defendant then brought the aircraft from Mexico to the Apex hangar at Austin Executive Airport for this pre-purchase inspection. So the way the contract reads is, if after the inspection, the plaintiff still wanted to purchase the aircraft, he was required to let the defendant know within 3 days that he would take it as is. As is in this context, under the contract's plain language, means that it's delivered as is in compliance with the delivery conditions, which required that the airplane be delivered in an airworthy condition. So the inspection, what it turned out was that there were a number, dozens in fact, of airworthiness issues, and defendant had to remedy each of those in order to comply with the delivery conditions in the event that the plaintiff accepted the aircraft. So the inspection report was received by the parties and the parties acknowledged that they received it on Thursday, April 18th, 2024. And that triggered the 3 business day acceptance period. And within those 3 business days on April 23rd, April 21st, the plaintiff accepted the plane as is, which means as is subject to the delivery conditions. I'll take it as is, but it has to be airworthy. That was what the contract requires. So what plaintiff's acceptance did is it triggered 3 things that are important here. First, it made the $50,000 deposit non-refundable. Second, it meant the defendant had 3 business days to deliver the aircraft to the plaintiff at the Austin Executive Airport, where it was. And lastly, it meant that the defendant had to fulfill the delivery conditions, one of which, the most prominent of which, is that it had to make the plane airworthy, and it had to fix the things that were addressed in the inspection report. The next day, after the plaintiff accepted the aircraft as is subject to delivery conditions, the defendant emailed plaintiff and repudiated the contract and said, I'm not gonna comply with it. And right after repudiation, the defendant moved the aircraft to a different hangar. It was still at the executive airport here in town, but it was in a different hangar. It was not at the Apex hangar, which is the site of delivery. This date is important, which is April 22nd, because this represents the last peaceable, non-contested status of the aircraft. Because that's when the dispute arose, when the defendant sent an email repudiating the contract.
You cut out there, Mr. Johnson, a little bit.
Oh, I'm sorry. So that date, April 22nd, is the key date here, because that was the last date of the actual non-contested peaceable status of the aircraft while it was at the Apex hangar in Austin. And like I said, that same day, the aircraft was removed to a different hangar at the executive airport. And then on or about May 8th, I think, it was taken back to Mexico. And that's where it is right now. And so that's the background, Your Honor. Here, it's understood that there are 3 elements that a plaintiff has to show to have an application for TRO granted. The first is a probable right to relief. Now, that doesn't mean that you have to prove your case. What it means is that you have to produce some evidence supporting each element of at least one legal claim. And here, there's evidence that has been presented through the verified pleadings that's clear of a breach of contract by the defendant. The second is that there's a probable injury, and here the injury is clear. The airplane, which was supposed to have been delivered in an airworthy condition 3 days after acceptance, meaning on April 24th of this year, it still hasn't been delivered. That's an injury to the plaintiff. Part of probable injury is imminent harm. That's one of the sub-elements. Here, the harm has occurred and it's ongoing. The plane is still in Mexico. And the other sub-element is that there needs to be an irreparable injury here. And that's really the important issue here. Typically, as Your Honor knows, when you're dealing with a contract and breach of contract, money damages can be awarded And so there is no irreparable harm. That's not the case here. And the reason that it's not the case is that the parties, first of all, didn't provide for monetary damages in their contract. What they provided for was specific performance, an equitable remedy. And specific performance, one of the elements of specific performance, in order to get it, if you're bringing that as a remedy for breach of contract, is that you have to show that money damages aren't going to make you whole. And what the parties did by agreeing to specific performance here is that they agreed before the fact that this is for a particular aircraft. Whatever money damages we might come up with, those are not going to make the plaintiff whole. The only remedy here is specific performance. That agreement in and of itself made this aircraft unique. And so you have two elements of two things and two ways in which the plaintiff will suffer irreparable harm. The aircraft is in Mexico. The seller, the defendant, is actively shopping it. And we know that because the seller entered into a contract to sell it, right? And then dropped out of it. If the defendant were to sell it to another party, then the plaintiff would lose the ability to compel purchase of the aircraft, compel specific performance. That's irreparable. When you lose that equitable right, there is no legal remedy that makes up for it because the two are different and they don't overlap. And that's the whole point of specific performance, is that you say money damages aren't enough. We are going to compel this actual object of the specific performance. We're going to make you, defendant, sell that, follow through on the contract, and sell that to the plaintiff. That's what the parties negotiated for. If the plaintiff lost that right, there is no remedy at law for that. And so we would, based on that, suggest to the court that this is the perfect situation for a temporary restraining order. When you have a claim for specific performance, that claim goes hand in hand with injunctive relief. Because if you lose the object of the specific performance, you've lost the ability to compel performance, and you've lost something that is not replaceable. And the parties here have agreed that this aircraft is not replaceable. The status quo ante, like I said, was when the aircraft was at the Apex hangar here in Austin. It's no longer here. We're asking for an injunction compelling, a mandatory injunction compelling the defendant to return the aircraft to Austin, which is where it was supposed to be delivered. It's where the inspection occurred. It is the only place that is actually listed numerous times in the contract as being an appropriate place for it. It's also the last place it was before the dispute arose. And we're asking for that, for the return of the aircraft here, and that nobody touch it, that nobody use it, nobody sell it, nobody part it out, and it stays at the Apex hangar. Staying at the Apex hangar, there's not going to be a charge for that. There will be no harm to the defendant except for potential loss of use of the aircraft while the dispute is going on. But that would be the case regardless of where the aircraft is, because when you use an aircraft, then the value of an aircraft is determined in large part by the number of hours that it has on it. So it just needs to be left alone, and we would request that Your Honor grant that injunction, ordering the defendant to bring the aircraft back here and for no one to utilize it, and just for it to be there until, first of all, we can have a temporary injunction hearing, and second of all, until this dispute is resolved. Thank you, Your Honor.
All right, Mr. Slim.
To correct a few misstatements, the defendants did not receive $50,000 in escrow money. The very first exhibit to the second amended petition, 3 pleadings in, by the way, second amended petition, is an acknowledgement of receipt of the escrow money by an escrow agent, a third-party escrow agent of plaintiff's choosing, which brings me to my next issue. Who's the plaintiff here? The contract was signed by a guy named Joe Alderman individually. There's no representation or there's no reference to an entity, Afo Holdings. I raised this in my response. And even as of the second amended petition, we still don't see an assignment of any rights or the purchase to Afo Holdings. So, as far as I'm concerned, Afo Holdings is a stranger to this agreement. Lest they then claim irreparable harm, do they, even if they did get an assignment to this deal, did they buy into irreparable harm? No, I don't think you can do that. If the plane was already not going to be delivered, if the deal was already repudiated, as they say, and I'll show you why, in fact, they're the ones that repudiated it, not Mr. Guerra, then no, I don't believe AFO Holdings can claim any irreparable harm. As to as to the delivery conditions, there are no delivery conditions. This is all a complete fabrication, Your Honor. There is a section in the contract 2.6.2, I believe, and I'm happy to do a screen share with you if you'd like me to direct you through some of that. That says has to be airworthy. Fine. They took a 2-hour test flight. That's airworthy. It can't violate any FAR 91, federal air regulations. It's an FAA regulatory standard that basically says you can't defer maintenance. It has to be in good condition. All right, fine. And if there's any deferred maintenance, it needs to be addressed. But what they didn't tell you, what section 4.2 of the contract says in all caps, Mr. Guerra is not a dealer. Mr. Guerra is not a manufacturer. This airplane is being sold as is, where is, with all faults. There is no exception. The very first word of that section is notwithstanding. Notwithstanding anything here to the contrary, meaning this bold provision applies, supersedes everything else. Notwithstanding anything else to the contrary, as is, whereas, with all faults. They come back with a bucket list of 120 items that they want addressed. That doesn't sound like an as is, whereas to me. Mr. Guerra for M&V says, wait a minute, what are you talking about? We don't have to do all this work. And we certainly, even if we did have to do all this work, we're certainly not going to let Apex do it. M&V has its own mechanic. M&V has its own mechanic that's been taking care of this plane for however long M&V owned it. Nothing in the contract says the airplane has to remain at Apex. So there again, misreading that. It says it goes to Apex for the inspection and it goes to Apex for the delivery. But if any of those things on the bucket list have to be addressed, they can be addressed at M&V's convenience and by M&V's mechanic. As to irreparable harm, this is one of 8,000 aircraft that's been produced. These aircraft have a cumulative 40 million hours on them. Sorry, you disappeared from me. I'm looking at Mr. Johnson. I don't know why. There's nothing unique about this aircraft, and there's nothing about a specific performance provision that makes it unique and irreparable. What Mr. Alderman did, not AFO Holdings, remember, AFO Holdings has no place in this lawsuit, at least not from the record before you. What Mr. Alderman did was he took Exhibit B to the contract. Exhibit B was you check a box for acceptance or you check a box for rejection. Mr. Alderman didn't do that. He drafted a brand new Exhibit B. Had he checked the box that was in the contract, that would have been consistent with the as-is provision, the all caps as-is provision that I read to you or referenced to you. It doesn't provide anything about delivery conditions, repairs, etc. And the way that contract reads or should read, it is ambiguous because there's something of a contradiction. But when you look at the word notwithstanding, that to me means no, there's not a contradiction. This provision wins. It's an as is, where is. And that Exhibit B says exactly that. It says, I accept this airplane as is, where is, with all faults. He didn't do that. he redrafts a whole new Exhibit B, signs it, and the new Exhibit B says, oh, and I want all those delivery conditions addressed. Well, wait a minute. Are we just ignoring the as-is provision, section 4.2 on page 8? Are we just ignoring that the Exhibit B to the contract was consistent? So no, they don't have probable right. And I'll correct him again. This is not a summary judgment proceeding where he has to provide some evidence of the elements. He has to provide a over 50%. That's why it's called probable. He has to show that he'll probably win. And I've shown you in the contract why he won't. The contract, the claim itself being fungible, there is an adequate remedy at law. He also misstates the remedies provision. It is not it's either specific performance or nothing. That's the acceptance provision. He can choose to reject, and then guess who gets the escrow money? The purchaser. So the contract is not only an as-is contract, it's also illusory, because the purchaser gets his earnest money back if he chooses to reject. Therefore, there's no consideration. I've addressed that in my response as well. They want to alter the status quo. They say the airplane is being actively marketed. Nothing in the record indicates that. And Mr. Guerra is with me right now. He can tell you himself, although I know this is an evidentiary hearing. No, it's not. This airplane was not for sale. Mr. Guerra was approached by Mr. Alderman's agent and said, hey, would you mind selling us your airplane? And Mr. Guerra said, well, I'm not really for sale, but you're going to send me an offer, and that's where we are today. So the airplane is in Mexico, not because it's being hidden or secreted, because that's where it lives. Mr. Guerra is a Mexican national. He does have dual citizenship, and he does not have a Texas address. The address where they say is his is actually his son. When he comes to Texas, he visits with his son, who they also incorrectly named in the lawsuit. They made it very clear to us, Your Honor, that they're not willing to play. They have infinite money. This is a matter of principle for them. They're not paying attorney's fees, and they just don't care. I don't think that is somebody who should be heard to walk in here with equity, to ask for equity and fairness. That, to me, is abusive process. If they want to sue for damages, they have that right. Common law tells them exactly what they can do, difference in value, etc. My client is ready and willing to hand over the airplane if they provide the proper Exhibit B, the proper acceptance, and the proper as is. That was never the issue. They wanted to hold the plane hostage, and they want you to participate in it by making you give the airplane to Apex, which is the purchaser's agent, the purchaser's mechanic, and it has to stay there for how long? What about a 120-item bucket list? What about all the lost use? My client still owns that airplane. He's entitled to use that airplane. If there's anything that has to be paid for use, well, that can be addressed. We know how much an airplane costs per hour. It's very calculable. It's even tax deductible. We know exactly what those numbers are. There's no mystery here, Your Honor. So I think a temporary restraining order, my last point, temporary restraining order is improper because there's been no showing that there would be irreparable harm between now and a temporary injunction hearing. Nothing at all, which you could probably schedule that in a couple of weeks. And it's been a couple of weeks over that since they filed the lawsuit. This is purely an abusive process, not an appropriate forum for TRO. Thank you.
Mr. Johnson, it's your motion, so you can have the final word. I will say our next hearing is set to start at 2:30, so.
I understand, Your Honor, and I'll be brief. All of these defenses that Mr. Slim is raising, those can be addressed in an evidentiary hearing. That's not here, and it misstates the burden of showing a probable right to relief. And I'm quoting from the 2019 Dallas Court of Appeals case, Smith v. Nerium, that plaintiff must present enough evidence to raise a bona fide issue as to its rights to ultimate relief. And it goes on to say plaintiff must produce some evidence supporting each element of at least one legal claim. Plaintiff has done that through verified pleadings. Let me address a standing issue really quickly. The contract, which is Exhibit A to our second amended petition, is between M&V Aviation Holdings and Joe Alderman or assignee. Okay. And what we say and what Mr. Alderman attests to in paragraph 12 of the second amended petition is that he assigned, as he was allowed to do, he assigned the contract to the plaintiff here, Afo Holdings. And he's the sole member of that. It's a direct affiliate, and it's specifically allowed. He's specifically allowed in the contract to do that. He did that. It's not a statute of frauds issue. He doesn't have to show a writing that shows that. He has testified in the pleadings that that's what he did. So the standing issue is not really an issue. Again, going back to the irreparable harm, just very quickly, the irreparable harm here, the contract supersedes the common law in the sense that the parties agreed what the damages, what the remedies would be. They do not include money damages. There is no amount of money damages that can make my client whole. That's why the parties agreed to and specifically bargained for specific performance. If something happens to the airplane in the meantime, before he can compel performance, then he's lost that right, that equitable right, which was a big part. He says in his verified pleadings, that was a big part of the bargain for me. I would not have entered into the contract without that provision. And I'll leave it at that, Your Honor.
Okay, well, Mr. Johnson, let me ask you this. Mr. Slim indicated his client's position is that the plaintiff is actually the one who breached or repudiated this deal by coming up with a new Exhibit B, not executing what was given to him, which I guess their position is vitiates the as-is clause. What's the response to that?
Yeah, so what the contract says is that the plaintiff to accept the aircraft after the inspection has to respond within 3 business days from the inspection using a form that is, and these are the words from the contract, substantially similar to Exhibit B to the contract, which Your Honor has. What was produced, Mr. Slim makes it sound like Mr. Alderman created an entirely new document, has no similarity at all. It is the identical exhibit in Exhibit B, except it adds something that says, hey, I'm accepting as is, but I'm not waiving my other rights under the contract. All he's doing is he's not adding anything that's not already in the contract. He's just saying, I want to make clear that I'm not waiving any of those other rights, specifically the delivery conditions. And I want to point out too that in Exhibit B to Exhibit A, which is the Exhibit B to the contract, it says as is subject to delivery conditions. It says that specifically. And the main delivery condition is that the aircraft be delivered in an airworthy condition. And so it's not that you take it as is and you take it all the warts. It says as is subject to delivery conditions, meaning as is, but it has to be airworthy. If the toilet doesn't work, if lights don't work, you're taking it as is. But subject to delivery conditions, the primary one is that it has to be airworthy. You have to deliver an airworthy aircraft. That's how I'm accepting it. And that's exactly what the plaintiff did here.
Okay. All right. I think I understand both parties' positions. What I need to do that I really have not had adequate time to do is I'm going to study the contract and what has been put in front of me a little bit more closely now that I understand the positions. So I have another hearing and someone waiting on us now, and I think another hearing at 3. So it may be closer to the end of the day before you hear back from the court on the application for the TRO, but you'll probably hear back from my staff as far as what decision has been made, but I don't have any further questions for you, and I appreciate your time this afternoon in the virtual courtroom.
Thank you, Judge.
All right, thank you. Best, take care.
Hi.
You're
You
excused.
Were you able to reach the dad?
Yes, ma'am. I did send him the information.
Okay. All right. We are on YouTube since this is a remote hearing.
All right, good afternoon. Welcome to the 200th District Court. This is Judge Jessica Mangrum. We're here in cause number in the interest of the SW. Ms. Williams, you were requested to put the other party on notice. Where is he? I can't hear you.
Can you hear me now?
Yes.
I texted him and asked for an email. He did not send me an email, so I sent the screenshot of the email that I received and sent it to him.
Okay, and did you receive a response?
He said I would have to look at the messages, but I told him that we was going to court, and I sent him the information. Since he didn't want to give me his email address to forward it to him, I just screenshotted it and sent it to him.
Okay, my question was, what was his response?
He just said, "From who?" I didn't get nothing. And I said, "What's your email?" He didn't say nothing. So I sent the screenshot, and he sent a paper saying something about the child. He sent a screenshot of something. I have no clue. I'm sorry, but that's all he said. He didn't. I told him 2:30. I gave him all the information. He just said he didn't get nothing. I was like, I'm trying to send it to you.
Okay, I just want to stop and make sure you're not driving. I see that you're in a car.
I'm just sitting in the car. I'm not driving. I'm parked.
Okay, great. Okay, well, so my preference would be to have him present at this hearing. It does not really assist the court in hearing from one side and not both sides. So I guess, since he isn't here, you told him the hearing was at 2:30?
Yes, ma'am, I did.
Okay, I'm going to ask that you take a break and call him right now and see if he can log on to the Zoom meeting.
Okay, hold on. He didn't answer.
Okay. All right. Well, we have another hearing at 3 o'clock. So why don't you go ahead and tell me a little bit more about why you're asking the court to issue a writ of habeas.
We had an altercation.
Okay, Miss Williams, you're cutting out. I need you to, I don't know if you have a good connection or where you are. I can't hear you.
Can you hear me now?
Yes.
So we had an altercation, and it went left. When he was picking up my son, he got mad because my son didn't want to go with him. He started crying, started blaming me, saying that I'm the reason for him acting like that, and I was jeopardizing their relationship. So it was hands put on one another. He called the police. I went to jail. So when he took him Friday, the police had told him that to bring him back Sunday at 6 p.m. He did not bring him back Sunday at 6 p.m. He said he's not bringing him back. He doesn't want to return the baby. I can't call and talk to him. He calls me whenever he wants to. I didn't even get to see my baby on Mother's Day. And when he did call me at 9 p.m. on Mother's Day for me to talk to him, it was just for a little bit before he took the phone and hung it up. I talked to him last Thursday, and that's when my baby was crying, saying he missed me. He wanted to come home. I tried to tell George, Sandon George, plenty of times, can you return the baby? Can you bring him home? He just keeps saying no. So I didn't know what else to do, which is why I reached out to a lawyer to get consulted on what to do. And that's how I ended up going to the court to file the papers to return the child.
Okay. So do you believe that the child is in any danger?
No, I don't believe he's in any danger. He does have a protection order on me, and he's using the protection order to keep Sadavian with him. I am aware of the protection order in the terms of the protection order. So during a transfer, I will not be here. But he doesn't want to return the baby. I haven't seen him in 2 weeks and 5 days. I haven't seen him since the day that he took him on May 3rd when I was put in jail.
Okay, and you do have there is a
Child
companion
support order.
case. Yes, you do have an custody order in place from 4D court that has who's supposed to have the child when.
Yes,
that type
ma'am.
of thing. Okay, and so he's in violation of that order at this point in time.
Yes, ma'am.
Okay. So, okay, give me a moment. I just want to look at a couple of things here.
Okay.
All right, Ms. Williams. So, generally speaking, for the court to issue a writ of habeas, that is a very, since Mr. I'm sorry, is it Mr. George?
Yeah, his name is Sandon George.
Okay. All right, Mr. George isn't here. And we don't have a good email address for him. Is that right?
Yeah, he wouldn't give me the email address, so I couldn't forward the message to him. Like the protection order is not against my son, it's against me and him. But he's using the protection order to hold the baby hostage from me.
Right. Okay.
And I haven't seen him. And I only get to talk to him when he allowed me to talk to him. And I don't think that's fair. The baby been with me since he was born.
All right, Ms. Williams, do you have, does anyone have a motion for temporary orders on file or any other pending? Do you have any other pending motions other than this one?
No, the motions that you have is the ones that I filed this morning.
Okay.
Hey, I'm not no bad mama. I've been a mama for 17 years and I ain't never went through none of this till now. I ain't never been in trouble and I ain't never had no problems with my kids.
All right, Ms. Williams, can you give me his telephone number?
512.
All right. I'm going to have my staff attempt to contact him and see if he will join this hearing. Just bear with us. It's just going to be a moment. I'm just going to turn my video off while we see if we can reach him. But
Okay.
You can do the same if you like, but I will let you know when we're ready to proceed.
Okay.
All right, Ms. Williams, my staff was unable to reach him. I'm going to take this matter under advisement. I want to look at possible options and solutions, including possibly resetting this matter later today or tomorrow if Mr. George can be available so that we're all in the same place and can understand what's going on.
He's trying to run from it.
I'm sorry, what?
He's trying to run from it.
Okay, well, that may be. But regardless of whether we're able to reach him or not, the court will issue a ruling on the request and let you know. But that may not be until later today or tomorrow. Okay, but you will hear back from us. I appreciate your patience this afternoon and thank you for being here. But I'll go ahead and excuse you from the quorum.
Okay.
All right. take care.
Thank you.
7 Independent Bank versus JP Morgan Chase Bank et al. Mr. Savrick, you represent the applicant, so you can go ahead. The court has reviewed the application, but you can go ahead and tell me.
Sure. This is very fluid. In fact, we're going to have to amend to add another. We found another Haken entity that we need to make sure gets added to this. So here's essentially what's going on. The bank made 4 loans to entities owned by Mr. Helms to construct homes. Mr. Helms died in February of this year. The homes are way underwater as far as the loan advances that are going. There's missing money. They're not complete. And the bank has got a foreclosure set for next month to foreclose on the 4 homes. And there's going to be quite a bit of loss that's going on. In reviewing the accounts, they noticed movements of money into entities owned and controlled by Mr. Helms. Those are those Haken entities. They were not borrowers on the accounts, but large sums of money that were deposited for the job were moved into this other account. And what we're asking the court to do for just 14 days is to freeze that money. It is a guess, and I'll say we have reason to believe that since Mr. Helms passed away, nobody has been able to do anything with those accounts. We don't even know how much money is sitting in those accounts on there, but we're just, until everybody can get their handle on it, just asking the court to put a freeze on it for 14 days till we can have an injunction hearing. I have spoken with the lawyer for Miss Helms, his widow, who is tomorrow going to be appointed as independent executor. And I've also spoken this afternoon with the probate attorney to explain to them what's going on. They are watching by the YouTube channel. They're a little afraid to appear because they don't represent Haken on this. They represent the estate and they represent Miss Helms on that. Our fear is that once Miss Helms is appointed as independent executor, that she can start acting as Mr. Helms or as the estate and start moving the money out of that account. We just want the money to stay there. We're not saying right now that we're asking you to pay it to us. We're not trying to garnish it. We're just trying to say, let's put a freeze on that account, protect Chase Bank too from that account to have it just held there, and let us get that sorted out. And so that's why we're asking for the TRO. This is, if there's money there, it has sat since February, and that there's not a big risk to those entities because they're not really operating at this point. And that's what we're asking for. And like I said, I don't know who the lawyer is for the bank. There is no lawyer for Hakem, but I have dealt with the estate lawyer and Miss Helms' lawyer in trying to let them know what was going on.
Okay. Have you contacted the court administrator's office about a date for the TI hearing?
I have not, but I can get that done, get that set. What I really like to do, just because minutes ago found out about this other Hakem entity, I'd like to amend and send you an amended order, and in that order we'll have got a date from the court coordinator for an injunction hearing.
Okay, that's fine. I guess you'll probably need to file an amended petition as well.
I'm going to do an amended petition, and I'm going to do an amended order to clean that up so that we cover everybody, so I don't have to come back to you.
Okay.
And then in that proposed order, we'll have the date for the hearing set out.
Okay, if you could get that to Ms. Seeger whenever you have it confirmed with court admin, based on what I have heard, the TRO is granted, and if you could just get that amended application filed to include that last entity and the order revised and sent over, we'll take care of it.
Will do. And now I thank you very much for your staff. They're awesome. Having just dealt with another district and trying to your staff is amazing and how fast they reacted in their communication. So I really do appreciate it.
Sure. Well, it is very busy when you are handling duty week. So yeah,
they're amazing.
They are great. That is true. So I appreciate you mentioning it. And Mr. Savrick, seeing nothing else, I will go ahead and excuse you from the courtroom.
Thank you. Thank you very much.
Take care. Thank you.